Representative Baining.
Thank you, Mr. Speaker and members of the Assembly. House Bill 1428 received a due pass recommendation from your Committee on GVA on an 8-5 due pass vote. House Bill 1428 is a simple bill. Basically what it does is allows legislative management may review any executive order issued by the President of the United States which has not been affirmed by a vote of Congress of the United States and signed into law as prescribed by the Constitution of the United States, and recommend to the Attorney General's office and the Governor that executive orders be further reviewed to determine the constitutionality of the measure and allow for a state for an exemption. As stated by President Obama of the State of the Union to Congress on January 2013, and I quote, "I urge Congress to get together, pursue a bipartisan, market-based solution to climate change, like the one John McCain and Joe Lieberman worked together on a few years ago. But if Congress won't act soon to protect future generations, I will direct my cabinet to come up with executive action we can take now and in the future to reduce pollution, prepare our communities for the consequences of climate change, and speed the transactions to more sustainable sources of energy," unquote, by President Obama. What does this mean? Could the President sign an executive order ordering, limiting, for that matter, outline fracking without Congress even acting or weighing in on this? I think he could. And for the matter, he might, to stop the so-called climate change, or better known as global warming. Now, members of the Assembly, would you not want the legislative management review this type of an order and the Attorney General and the executive branch to weigh in on and decide? I think they should. By reading this paragraph from the State of the Union speech before Congress, it seems that the President is making law and circumventing Congress by making law through executive orders, something that is not in the Constitution under his powers. Mr. Speakers and members of the Assembly, I urge a due pass in 1428.
Is there any discussion? Representative Mooney.
Thank you, Mr. Speaker and members of the Assembly. I have grave concerns with House Bill 1428 and would ask your consideration for a do not pass. Throughout history, our country has had many times of trouble, times of controversy, times of great discourse, and times of great pain. In my own lifetime, I can think of a very few specific instances that really exemplify this. The civil rights movement and integration of races in the 1960s. The Cold War that kept everyone in doubt and suspicion until its effective demise when Ronald Reagan asked Gorbachev to tear down the wall in 1987. The day we all remember with vivid clarity in 2001 when terrorists forever changed our world, literally and figuratively. The point? That even if we disagreed or had our own personal biases, the fact remains that we stuck it out, we stuck it together, and we became better because of it. This bill seems to fly in the face of that very democratic, extremely American position. If we were to place caveats to the presidential orders, it would seem not only appropriate, but of supreme importance to have an understanding of the types of orders that we would be questioning. After all, an executive order can address a wide variety of items that range greatly in topic, from housekeeping issues to orders of great importance. Executive orders have included issues such as Executive Order 9981 by Harry Truman that prohibited racial, religious, and ethnic discrimination in the armed forces. Number 10925 by President Kennedy that created the Equal Opportunity Commission. 11246 by President Johnson that prohibited discrimination in employment decisions on the basis of race, color, religion, sex, or national origin. 11490 by President Nixon, which placed national emergency preparedness in the hands of specific agencies and is arguably one of the first executive orders to be disputed based on constitutionality. 11905 by Gerald Ford, which outlawed the use of political assassination. 12170 by President Carter that allowed the freezing of all Iranian assets held within the United States. 12601 by President Reagan that instituted the President's Commission on the HIV epidemic. 12711 by George Bush that deferred deportation of Chinese nationals and their direct dependents in response to the Tiananmen Square protests of 1989. 12959 by President Clinton, where he effectively eliminated all trade and investment and virtually all interaction between the United States and Iran. 13239 by George W. Bush, that designated Afghanistan and the airspace above it as combat zone. 13626 by Barack Obama, relating to the Gulf Coast ecosystem restoration, and number 13628, which authorized additional sanctions with respect to Iran. The point behind all of these examples is simple. You and I as individuals and as a legislative body may not like, or we may like or dislike any of the executive orders that have been put into place since the time of George Washington. But the safeguards do not lie with individuals and do not lie with individual states. That task lies with congressional and Supreme Court processes. While neither of these processes are simple or quick, they are appropriate, and they are the correct bodies of government to question a president's judgment. The sheer hubris of HB 1428 renders it hollow and with no real purpose other than to posture, create further division through negative and pertinent legislation, leaves far too much for interpretation as to a good versus a bad order, ultimately leaves a person wondering just what negative effects might come from it, and sends the wrong message to North Dakota citizens, sub-governmental entities, and to the nation. Mr. Speaker, ladies and gentlemen of the Assembly, please, I urge you a red vote on House Bill 1428. Thank you.
Representative M. Nelson.
Thank you, Mr. Speaker and members of the House. I find this to be an interesting resolution because basically we're claiming that the federal government doesn't have its house in order. Yet really what it's pointing to is to us and how we don't have our house in order. We're asking legislative management to review it and then ask the Attorney General and the Governor for a constitutional opinion. Well, we have to do that because we can't ask for a constitutional opinion from the Attorney General. Only state officers can. And what's more, the Attorney General drops on all of our desks his policies concerning when and when we can't ask him opinions. Many of you would be familiar, for instance, with the fact that during the session, you're not supposed to ask unless your leader says you can for an Attorney General's opinion. Well, we have a law. We have a law that says administrative agencies will reduce such policies to administrative code. We haven't made the Attorney General do that. We haven't enforced our own law. It would be quite proper, I would say, for us to have a rule in this House that members would not ask for an Attorney General's opinion during the legislative session. But it is not proper under the laws of the state of North Dakota for the Attorney General to have a policy that tells us that we can't. So really, unless we're willing to get our house in order, and even if we are, I'd say first we should do that, and then we should tell the federal government to get their house in order. Thank you.
Is there any further discussion? Seeing none, the House has before it for final consideration House Bill 1428. The clerk will open the key and you may record your vote. Has every member voted? Does any member wish to change their vote? Key will be closed and the clerk will take the record. The final votes are 66 yea, 27 nay, 1 absent, not voting. House Bill 1428 is declared passed.